Hi, my name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. Today we're continuing our video series on family law issues. We're going to talk about show causes today, so please subscribe to our channel. There are times when, even though the court gives a court order, there's an allegation that the order has been violated. The way the allegation comes up is there will typically be a motion filed by the other side. The motion may very well be a motion seeking an order to show cause why somebody should not be held in contempt for violating the court's order. I'll give an example. Suppose the court says that there's parenting time and the child's to be brought back Wednesday night, 8 o'clock. Father brings the child back Wednesday night, 9 o'clock. Routinely violating the order. You say, hey, you're an hour late, don't do it again, next week, 10 o'clock. In other words, always violating. If that's the situation and you feel that you want to go down that road, you need to contact your attorney, discuss with him. He or she will tell you whether or not it pays to fight over that time. Then you can decide if you want to file the motion to show cause. If the court's order has been violated, the court will set up a hearing to determine what it's going to do about it. But remember one thing, the court has options. The court sees that it should be involved only as a last resort. The court doesn't view itself as the first place you turn to when something goes wrong. So if a guy's a little late about bringing the child back from parenting time, mom should have showed up at a certain time, she was late, whatever, the court might not necessarily hold somebody in contempt for being 20 minutes late. Quite the reverse. The court might extend the parenting time 20 minutes. If dad says, you know what, because of work, I just can't get there by 8 o'clock, so I show up at 8:20, the court will say, very well, we're going to extend the visitation 20 minutes, and that may solve your show cause in a way that you didn't want it solved. So you got to be very careful. You got to choose your battles wisely. You got to decide whether or not it makes sense to pick that fight. Remember one thing. You're maybe divorced, after 2 years of marriage, but your parenting will last, and as far as the court's concerned, until generally the child's 18 years old. That means you're going to have to be dealing with that other parent for a longer period of time, and the court doesn't want to see you there, every week arguing about ticky-tacky stuff. So you've got to choose your battles wisely. Be judicious about what you bring before your lawyer. Understand what the show cause is and what the court will do. The court may say, yes, you violated, don't do it again. And if you do it again, I may consider a stricter punishment. If that's what you get out of it, was that worth the $2,000 that it cost you to have your lawyer go through all that? File that motion, serve it, get a date from the court, prepare for the hearing, show up for the hearing, conduct the hearing. Was it worth it? Probably not. On the other hand, you've got to draw a line in the sand if you feel that you are being put upon routinely. You've got to set boundaries. And sometimes, even though you didn't get a whole lot out of it, it's worth it just to set the boundaries. But you got to prepare for it properly. Gather your evidence. Make sure that you have a basis for proving that the order was violated. On the flip side, if you are the person who's accused of a violation, get your lawyer involved in your defense. If you are routinely not showing up for parenting time, maybe it's appropriate to talk about modifying the parenting time that works for you. The court will always try to make its orders reflect the reality. If you're supposed to have parenting time every other weekend, but you never show up, expect that the court is probably going to change it. It's going to take away your parenting time, because if you're not utilizing it, the other side could utilize it better. The other side doesn't have to prepare the child and sit there waiting on you while you don't show up. So the court may flip it around on you. So you really got to be careful about how you're handling this. Now, each case is different. All the facts are case specific. If you have questions about yours, reach out, and of course we'll be glad to help you out.